My name is Alex Lorenzo, and I'm a partner in Alston & Bird's Litigation and Trial Practice Group. As litigators, we have a variety of tools and strategies to address the problems that our clients face. Today, I'd like to discuss one of these tools, the interpleader action, and some of its benefits. An interpleader is a lawsuit brought by a disinterested party, the interpleader plaintiff, facing competing claims from two or more other parties, known as the interpleader defendants. The interpleader plaintiff has no direct interest in the outcome of the dispute among the interpleader defendants, but faces the risk of multiple liabilities as a result of their competing claims. The classic example of an interpleader is one brought by an interpleader plaintiff holding funds that two parties assert that they are entitled to. If the plaintiff pays the funds to one of the parties, the other will sue, and vice versa. Thus, absent an interpleader, the plaintiff finds itself in a situation where it can't act without risk of liability to itself. While the classic interpleader involves a fixed sum held by the interpleader plaintiff, interpleader actions can be used in any situation where a party faces competing demands and cannot act without risk of liability to itself. This includes situations where there's a dispute between parties regarding future payments, the interpretation of a contractual provision, or the exercise of a right. These types of disputes often occur between different stakeholders in securitized transactions. Trustees for these securitized transactions often find themselves caught between the demands of competing stakeholders. For example, different stakeholders may have competing interpretations of the governing documents, and each may demand that the trustee act in accordance with their interpretation. This puts the trustee in a situation where it can't act without risk of liability to itself. Interpleader actions can be brought in both federal and state courts. Federal courts provide two avenues for interpleader: statutory interpleader and rule interpleader. The former is designed for disputes over a fixed sum and requires the interpleader plaintiff to either deposit the disputed funds with the court or to post a bond. In contrast, rule interpleader allows a broader scope of interpled claims, and to the extent funds are in dispute, they are not necessarily required to be deposited with the court. Statutory and rule interpleader also have different requirements for the minimum amount in controversy and for the exercise of the court's jurisdiction. State courts are also an attractive venue for interpleader actions. New York, for example, has a specific statutory provision for interpleader actions. And by filing in state court, an interpleader plaintiff is not limited by the specific jurisdictional requirements of federal court. Regardless of the forum, interpleader actions have many benefits. First and foremost, they avoid having the interpleader plaintiff sued by one or more of the interpleader defendants. While the interpleader defendants are free to file counterclaims against the interpleader plaintiff, the filing of the interpleader itself doesn't give rise to a claim for liability. And where the interpleader plaintiff deposits a disputed sum with the court, the interpleader plaintiff can move for a discharge, releasing them from the interpleader litigation. Further, where there's a dispute over funds, an interpleader plaintiff can move the court to have its costs and fees, including its attorney's fees, deducted from the funds in dispute. Companies that are involved in businesses that expose them to multiple claims from competing parties should be intimately familiar with the uses, requirements, and benefits of interpleader actions. Alston & Bird has a full team of litigators with extensive experience with interpleader actions and other strategies and can assist on these matters.